Today, we will talk about the Investment Advisors Act of 1940. The Investment Advisors Act of 1940 is a U.S. federal law that regulates and defines the role and responsibilities of an investment advisor. Prompted in part by a 1935 report to Congress on investment trusts and investment companies prepared by the Securities and Exchange Commission, the Act provides the legal groundwork for monitoring those who advise pension funds, individuals, and institutions on matters of investing. It specifies what qualifies as investment advice and stipulates who must register with state and federal regulators in order to dispense it. The original impetus of the Investment Advisors Act of 1940 was the stock market crash of 1929 and the Great Depression. In 1935, SEC report to Congress warned of the dangers posed by certain investment counselors, which led to the regulation of those who provided investment advice. This act, along with the Investment Company Act of 1940, defined the responsibilities and requirements of investment companies when offering publicly traded investment products. Investment advisors are bound to a fiduciary standard that was established as part of the Investment Advisors Act of 1940, and can be regulated either by the SEC or state securities regulators, depending on the scale and scope of their business activities. The Act specifies a duty of loyalty and duty of care, meaning the advisor must put their clients' interests above their own and provide thorough and accurate investment advice. The Investment Advisors Act applied three criteria to define who is and who is not an advisor, what kind of advice is offered, how the individual is paid for their advice, and whether the majority of the advisor's income is generated by providing investment advice. It also addressed circumstances where an individual can be considered an advisor, and provides detailed guidelines in Title 15 of the United States Code. Advisors register with a regulatory body based on the value of the assets they manage, and whether they advise corporate clients or only individuals. The Dodd-Frank Act of 2010 amended registration requirements for advisors, allowing many to register with their state regulators instead of the SEC. Additionally, the Dodd-Frank Act initiated registration requirements for those who advise private funds. Here are three key takeaways. 1. Financial advisors must adhere to the Investment Advisors Act of 1940, which calls on them to perform fiduciary duty and act primarily on behalf of their clients. 2. The Act imposes upon the advisor the affirmative duty of utmost good faith and full and fair disclosure of material facts as part of their duty to exercise client loyalty and care. 3. Investment advisors are required to pass a qualifying exam and register with a regulatory body as part of the Act. Hope this would help. Thanks for watching.